number. The NFA injunction just changed the rules. Here's what gun owners need to know. Can an American gun owner take a pistol brace off an AR pistol, install a standard shoulder stock, and assemble a short-barreled rifle without filing an ATF Form 1? Ever since a federal district court issued a preliminary injunction against certain National Firearms Act requirements, that question has dominated the firearms community. Gun owners have been trying to understand exactly where the boundaries of this court order lie. Now, the legal team that represented the plaintiffs and secured the injunction has provided one of the clearest and most detailed explanations yet. But before getting into the practical questions, there is an important distinction to understand. This is not new ATF guidance. It is not a new ruling from Federal District Judge James Wesley Hendrick. And it does not expand the injunction beyond what the court actually ordered. Instead, this is legal analysis from Wiley, the law firm representing the plaintiffs in Silencer Shop Foundation v. ATF, the federal lawsuit backed by Gun Owners of America. Because these are the attorneys directly involved in the litigation and in obtaining the injunction, their interpretation carries significant practical weight. They are addressing the real-world questions that gun owners and firearms businesses have been asking since the court's decision. And their baseline conclusion is significant. For an individual who falls within the protected class covered by the injunction, taking an AR pistol with a barrel under 16 inches, removing the pistol brace, and installing a shoulder stock does not require going through the traditional Form 1 approval and registration process, according to Wiley's analysis. Under standard federal law, converting an AR pistol with a barrel under 16 inches into a shoulder-fired weapon can create a short-barreled rifle. Historically, the National Firearms Act required an individual making that firearm to submit a Form 1, obtain ATF approval, and register the firearm before making it. According to Wiley, Judge Hendrick's injunction prevents enforcement of that approval and registration requirement against covered individuals conducting covered-making activity. That is a major change. But the attorneys also issued several critical warnings that are easy to miss. The first is this: no Form 1 does not mean no legal requirement. The injunction targeted specific, challenged provisions of the National Firearms Act. It did not erase every federal firearm regulation. One provision that remains relevant is Title 26, United States Code, Section 5842A, which contains federal identification and marking requirements applicable to firearms makers, manufacturers, and importers. Wiley specifically warns that those marking requirements can remain applicable even when a covered individual does not have to go through the enjoined Form 1 process. So, the conclusion should not be reduced to, no, Form 1 means I can simply put a stock on the firearm and ignore everything else. That is not what the attorneys are saying. For factory-built firearms from manufacturers such as Daniel Defense or CMMG, the existing manufacturer markings may already satisfy applicable identification requirements. But unfinished receivers, homemade firearms, or other situations involving marking requirements can raise separate federal issues. And then there is another major consideration: state law. Judge Hendricks is a federal district judge. His injunction concerns the federal government's enforcement of the provisions challenged in this case. It does not rewrite state criminal codes across the country. Some states independently regulate short-barreled rifles. Some jurisdictions impose separate restrictions, while others may connect state law requirements to federal registration. That means a person considering the practical effect of the injunction has to look at two separate questions. What does the federal injunction protect? And what does the individual state law independently require? That distinction becomes even more important when we get to the difference between organizational membership and commercial customer status. This is one of the most important clarifications in Wiley's analysis. Suppose an individual is an active member of Gun Owners of America, one of the organizational plaintiffs in the litigation. According to Wiley's analysis, the organization brought claims on behalf of its members, and that associational relationship can provide the basis for protection when the member engages in activity covered by the injunction. Now compare that with someone who is not relying on organizational membership. Suppose that person purchases an AR pistol from one of the commercial plaintiffs involved in the litigation. That person is a customer in connection with that specific commercial transaction. But does purchasing that firearm mean the customer receives permanent protection for every future action involving that firearm? According to Wiley's analysis, no. The protection for commercial customers is transactional. In other words, the fact that someone purchased an item from a covered commercial plaintiff does not automatically create a permanent legal shield around that firearm or around every future activity involving it. Imagine someone buys an AR pistol today and then, 6 months later, decides to remove the brace and install a shoulder stock. That person cannot simply assume that because the original firearm was purchased from a covered company, every later activity involving the firearm is automatically protected by the injunction. That is fundamentally different from the protection Wiley describes for qualifying members of protected organizational plaintiffs. So membership status and customer status should not be treated as interchangeable. The same basic distinction applies to firearms dealers. Imagine an FFL receives suppressors through the distribution network of one of the commercial plaintiffs. Those particular products may be involved in covered transactions, but does having some plaintiff-sourced suppressors in the dealer's inventory automatically make every NFA firearm in that dealer's possession protected? According to Wiley's analysis, no. If a dealer has some suppressors sourced through a covered commercial plaintiff and other NFA items sourced from companies outside the litigation, the existence of the covered inventory does not automatically transform the unrelated inventory into protected inventory. Again, the protection follows the relationship that creates the protection. A dealer might potentially have another independent basis for protection, such as qualifying membership in a plaintiff organization. But simply participating in one covered commercial transaction does not automatically turn every NFA transaction conducted by that FFL into a protected transaction. And that brings us to one of the strangest practical problems raised by the injunction: the National Firearms Registration and Transfer Record, or NFRTR. The NFRTR is the federal registry used for NFA firearms. Consider a suppressor moving through the traditional commercial distribution system. An FFL receives the suppressor through the normal process, and the federal NFRTR records that suppressor as being associated with the dealer. Now imagine a customer who is protected by the injunction comes into the store under the analysis being discussed. The dealer may conduct a covered transfer without an approved Form 4 and without creating a new NFA registration for the customer. The customer still has to comply with applicable Gun Control Act requirements, including ordinary dealer paperwork and a background check process where applicable. The dealer also records the lawful disposition in its required business records. The suppressor physically leaves the dealer and goes to the customer. But if no Form 4 is processed, what happens to the federal NFRTR record? The database may continue to show the dealer as the registered party. That creates one of the strangest practical problems in the entire injunction. The suppressor can physically leave the dealer. The dealer can properly document the lawful disposition in its business records. The protected customer can lawfully take possession of the suppressor. Yet the federal registry may still show that same suppressor as being associated with the dealer. In other words, the physical firearm and the government's central registry can potentially tell two different stories. The dealer's records can show that the suppressor was lawfully transferred and is no longer in the dealer's inventory, while the NFRTR may continue identifying that dealer as the registered party. Wiley compares this kind of situation to an NFA firearm that has been destroyed, where the physical firearm is gone, but the registry can continue showing the former registrant until the government is properly notified. And that raises an important question. How will ATF reconcile a federal registry built around mandatory NFA registration with transactions that a federal court has now prevented the government from requiring to be registered? That is more than a technical database problem. For nearly 92 years, the federal government built an administrative system around the assumption that NFA firearms would move through a registration process. Now, a federal court has enjoined certain registration requirements for protected individuals and transactions. The legal requirement has changed, but the administrative system was built around the old requirement. Neither the ATF nor the Department of Justice has, according to the material discussed here, provided comprehensive public guidance explaining exactly how the NFRTR is supposed to reconcile these covered transactions. That leaves dealers and protected customers dealing with a system that was never designed for this particular situation. And there is another distinction that gun owners need to understand. Making your own SBR is not the same thing as buying a completed SBR from an FFL. The injunction addresses challenged provisions of the National Firearms Act, but federal firearms regulation does not exist entirely within the NFA. The Gun Control Act contains separate restrictions under 18 U.S. C. Section 922b(4). An FFL is restricted from selling or delivering a short-barreled rifle or short-barreled shotgun to an individual unless the Attorney General specifically authorizes that transaction. That provision was not wiped out by the injunction. Historically, the NFA Form 4 approval process provided the mechanism for obtaining the required authorization. So, Wiley continues to distinguish between making an SBR yourself while protected by the injunction and walking into an FFL and purchasing a completed SBR. Those are different activities governed by different federal provisions. Until ATF establishes some other mechanism for satisfying the separate Gun Control Act authorization requirement, Wiley's analysis is that the existing Form 4 process remains the cleanest practical route for an FFL transferring a completed SBR or SBS to an individual. So when someone hears that the Form 1 requirement has been enjoined, they should not automatically conclude that Form 4 requirements for dealers and completed SBR transfers have also disappeared. They are separate legal questions. There is also an important point about voluntarily using a Form 4. Nothing about the injunction necessarily means that a covered individual must take advantage of the new pathway. There can still be reasons someone may want or need traditional federal registration. State law is one example. If a particular state independently conditions lawful possession on federal registration, the fact that a federal court has prevented ATF from requiring that registration in a covered situation does not necessarily eliminate the state's separate requirement. Wiley's position is that voluntary Form 4 processing can remain available in situations where someone wants or needs that registration for state law purposes. Again, this is why the practical answer cannot simply be, Form 4 is dead. For some covered suppressor transactions, the injunction may remove the federal requirement for the traditional registration process. For other situations, particularly where separate federal statutes or state laws are involved, the traditional process can remain relevant. All of these issues lead back to the larger constitutional question at the center of the litigation. For almost 92 years, the NFA registration system was treated as a permanent part of the federal firearms landscape. Congress created the system around a federal tax, and the government built a large registration and approval structure around that framework. But when Congress reduced the relevant tax to zero, Judge Hendricks examined whether the remaining regulatory structure could still be sustained through Congress's taxing power when applied to untaxed firearms. That is what makes the current situation so significant. For a person who is actually protected by the injunction, the question is no longer simply whether an AR pistol can theoretically become an SBR. The attorneys who litigated this case are now saying that covered-making activity can occur without the traditional Form 1 approval and registration process. But that does not mean the entire National Firearms Act disappeared. Marking requirements still matter. State laws still matter. Organizational membership is not the same as being a commercial customer. Dealer protection does not automatically extend to unrelated inventory. Buying a completed SBR from an FFL remains a separate legal issue under the Gun Control Act, and the NFRTR may now face transactions that its existing system was never designed to handle. That is the real significance of this injunction. It is not unlimited permission. It is a major change to a system that operated for nearly 92 years, and the practical consequences are only now becoming clear. The federal government still has to explain how ATF and DOJ intend to administer a system in which certain registration requirements have been enjoined, while other federal and state requirements remain in place. For now, the most important thing is understanding exactly where the protection applies and where it does not. The injunction is real. The legal consequences are real. And as dealers, businesses, and protected Americans begin adjusting to this new reality, the next major question is no longer simply whether the old system has been disrupted. It is how the federal government is going to operate after that disruption. That is what we will be watching next.